So I do understand that these are very serious offenses. This is an isolated matter between Mr. Franks and his daughter. I don't want to put too many facts on the record, Your Honor, but this situation started because the child was told to clean her room. And instead of cleaning her room, she got on her phone. And so here we are. Mr. Franks' rent was due on November 13th. He was not able to pay it. I am not 100% sure if the child is still at the house, but I don't believe that she is because Mr. Frank's father went to the home to look for Mr. Frank's rent money and could not find it. And at that time, the child was not there. Also, as it relates to the animal in this matter, the animal does not belong to the child. The animal belongs to Mr. Franks, and Mr. Franks did not touch the animal. Mr. Franks was cooperative when the police arrested him. He's employed. He's been employed for about 3 months at Custom Work Construction. He's a 1099 contractor. So that is the reason he's not able to get a bail bondsman because he doesn't have, I guess, a W-2 or verifiable income. I would ask if the court would consider a high personal bond or at least a $5,000 10% bond. Mr. Franks indicated to me that he would at least be able to pay $500 to be released. I don't believe he's a danger to the community. He does have somewhat of a criminal history, but I don't see, and the prosecutor can correct me if I'm wrong, I don't see that he's been convicted of anything assaultive since 2015. He has ties to the community. His address is in Wyandotte. He understands if his daughter is there, though, he obviously have to go somewhere else. His family is in Wyandotte. I don't believe there's a failure to appear history, and I believe that he would appear at all court dates. So I would ask if the court would consider reducing the bond.
Okay, and Mr. Mohammed.
The judge, I would object. I believe the defendant poses a serious danger to the public. He does have an assaultive criminal history. In 2003, he had pled guilty to assault and battery. Again, in 2003, he pled no contest to assault and battery. He has a prior felony conviction of felonious assault, and that occurred in the year of 2012. He has a previous conviction of possession of methamphetamine, as well as two prior domestic violence cases. So this isn't the defendant's first rodeo with these types of offenses. He's a HAP-4, he's a serious danger to the public. And I'm not basing that just based off those previous convictions that I've mentioned, but also he has a operating with a high BAC conviction. So this individual, the defendant, has a very serious past, and I do believe he poses a serious danger to the public. So I would object. There's been no change in circumstances since the time he's been arraigned, so I don't see why we would amend bond at this time. So I object.
Okay, so here's what the court based its bond and conditions on. Now, granted, that the report is allegations and what the detectives swore to on the record, right? However, your client's current estranged wife contacted the police, is what's alleged, for a welfare check. And then from there is when all of this occurred, what have you. And whether or not the dog is your client's dog or somebody else's dog, there's an allegation your client was punching the dog. Further, your client has a history of assaultive crimes and convictions dating back to 2003 in Roscommon Court, assault and battery found guilty. 2003, another charge. There were two separate charges, one in January 6th of 2003 and another one November 4th of 2003. The one November 4th was felony weapons offense that was pled down to assault and battery. 2006, felony dangerous drugs was nolle prost. 2011, malicious destruction of personal property was nolle prost. 2012, felony assault with intent to do great bodily harm less than murder was nolle prost. Your client pled guilty to felony assault with a dangerous weapon. 2 counts of that. Another count of felony assault with a dangerous weapon, 2 other counts of those were dismissed, as well as a felony malicious destruction of personal property, nolli prost. Appears though that was a global resolution. There's a felony possession charge in 2014. 2016, domestic violence, your client pled no contest to on 2 counts, back up in Roscommon. Then 2016, your client pled guilty to unlawful driving away of a motor vehicle. Sorry, pled no contest, as well as in felony malicious destruction of personal property. And then that brings us to the current case. So this court has a serious concern for the safety of the community, as well as individuals, family members or whatnot associated with Mr. Franks. Further, there's also not to be lost that there's a child abuse 4th degree charge here, and whether this is alleged to have occurred from his daughter not wanting to clean up the room or what have you, it's escalated to this offense, to this level. There's also a domestic violence 3rd offense notice and a habitual offender 4th offense notice based upon all of these charges. Therefore, the court finds that its bond that it set is appropriate and is not, as well as conditions, and is not reducing the bond.
Okay, Judge, thank you, but can we still request the DSU report, Your Honor?
Yes, you may. All right, counsel, do you hear?